Well, as we mentioned before the break, a federal judge declared parts, not all, but parts of the strict new abortion law here in Texas unconstitutional, and it happened relatively quickly. So joining us now to talk about it in a little more detail is our legal expert, Doug Uloth. Doug, thanks for coming in tonight.
Thank you for having me.
And we were talking just during the break now how this actually happened pretty quickly and may have surprised people just because of the prompt nature of the ruling.
It did. It was originally filed as an injunction, which has to be attached to a longer suit, but the judge and the parties decided to take it straight to trial at the preliminary injunction level, so you went from the suit being filed to a final decision and a judgment probably 75 days or so, which is virtually unheard of, at least in the types of cases I'm ever in, so it was remarkably quick.
This bears all the marks of everybody knew that it's going to get appealed up to the Supreme Court if they'll take it, and they just wanted to go ahead and speed the process and get it there as quickly as possible.
I think very clearly that's true. In fact, I think the parties, perhaps in some of their comments to the press, indicated they all know that's where it's going.
Yeah.
And what are the likelihood or the chances that the Supreme Court would accept this?
They have a fairly unfettered discretion as to what they take. They have to regard it as something that's significant to the jurisprudence of the country. So it may depend on how it's phrased. If it stays as being some sort of fact-specific issue and it's couched that way, the court could pick it up and say, well, this is such a narrow ruling on such a narrow, limited basis that we aren't going to take it up and consider it on a broader issue. So it's very difficult to predict, I think, at this point in time, whether they will take it. It may very well stay at the next level, the Court of Appeals, which has to. Court
of Appeals now, will it go in Texas first and then to New Orleans, or does it go straight to New Orleans?
No, because Judge Yackel is a federal district judge. It will go from the Western District of Texas to the Fifth Circuit, and who sits in New Orleans. They have branches in Austin and elsewhere, but they'll probably have the full argument down in New Orleans. And first they can go to a three-judge panel, and then depending on what happens with that panel, they can ask for it to be heard en banc by the entire Fifth Circuit. So it wouldn't particularly surprise me if after a three-judge ruling, whoever didn't like that tries to ask for the full circuit to hear it.
And in the meantime, nothing changes, nothing happens. Women's access to these procedures will continue as before until there is ultimately a ruling. Is that right?
With respect to the specific issues that were before the court, there is one aspect of it of the bill that will go into effect. The ruling that Judge Yackel came down with basically said that the portion of the statute that had to do with requiring a doctor to have privileges at a hospital within 30 miles of where the clinic is struck down as being not with a reasonable or rational basis. He allowed a kind of loophole to exist with respect to the medical abortion process.
The pills?
The pills. Yep. He ruled that that part of the statute is not without a rational basis, but it basically stands unless in the medical opinion of a doctor he needs to go ahead and use the medication process. So, you know, one could say that that's a loophole that's as big as the law was originally, depending on the doctor that may give the prescription.
Any chance the legislature may come back with a new bill, a new law, and make this whole thing moot, or are they going to try to live with this?
They could conceivably, but you know, the session, we don't have another legislative session for 2 years, so likely I would think this may get to the Supreme Court by that point in time, just barely. The session starts in January in 2 years, and the court would be issuing rulings about May or so, so it could be a race. I heard today that one of the proponents talking about it said that the main issue that the proponents of the bill were interested in was the 20-week restriction, which stands. It wasn't even challenged, and the provisions that require the abortion clinics to maintain or meet surgical hospital standards, which don't even go into effect until September 1st of next year. So I think there will be a challenge to that, but they were just picking the closest fight in time, and the Planned Parenthood group filed this suit. I expect they'll file another one with respect to the surgical hospital standards issue.
And how is the Fifth Circuit likely to rule on this?
Well,
any way to predict? Who knows?
They're hard. They have not been favorably disposed in the last two times. There was a decision by Judge Yackel, also Sam Sparks, who's the judge also in Austin, had reached a ruling on some other abortion-related issues in 2012, both of which were reversed at the Fifth Circuit. So they are regarded as being a fairly conservative circuit. So in other areas of the law, they are pretty conservative, and so in this area, the flags they're raising have been that they tend to like to let the states regulate.
Yeah.
Okay.
Well, sometimes it's kind of like trying to read the tea leaves, I guess, to predict. So, but we really appreciate your expertise. So, Doug, Uloth, thank you for so much for coming in tonight.
Well, thank you
to
for
help
having
us
me.
take a look at this issue and what might happen next.
May have Doug back again. As the
Yes,
season
yes.
continues.
Keep us on your dance
This
card.
is the first cannon shot.
Right.
Yeah.
More to follow.
Yeah.
Coming up next on the Texas Daily, we do know that one thing has changed on the Healthcare Exchange website. Do you know what it is? Well, it might just leave us with one big unanswered question. We're going to dig into that issue coming up next. Stay here.
There's a hint.
Yeah.